My name is Ming, and I'm going to discuss the roles of intention, presumptions, and unjust enrichment in relation to resulting trust. Resulting trusts are species of trust employed by law in which the original owner of the property is the beneficiary of the resulting trust. It only arises in the situation where the claimant intended to make the defendant a trustee. The property will result back to the original or rightful owner or settlor who becomes the beneficial owner under the resulting trust. Currently, there are two common ways of classifying resulting trust. In the case of Westuche, Landers Bank, Lord Brown Wilkinson categorized resulting trust into Type A purchasing price resulting trust and Type B failed express trust, in which the settlor fails to exhaust the whole beneficial interest. A purchase price resulting trust recognizes that the contributor of purchase price of property prima facie forthwith acquires an equitable interest in that property in proportion to the size of his contribution, in which equity presumes that the legal owner is holding that equitable interest on trust for the contributor. While for Type B, it fills the gap in equitable ownership as the settlor has failed to adequately dispose it to the recipient. It had been applied in Malaysia, where the federal court case of Takako Sakau and Ng Pek Yuan and another cited Lord Brown Wilkinson's classification of resulting trust into Type A and Type B with approval. While in the case of Rear Van der Waals Trust Number 2, resulting trusts are classified into presumed resulting trust and automatic resulting trust. Firstly, a presumed resulting trust is a prima facie rule of evidence arises where there is no definitive evidence in the first place concerning the transferor's real intention. It arises when a person did not intend to transfer the equitable title to the donee but makes a voluntary transfer of property or contributes to the purchase price of property, which is either registered only in the donee's name or is registered in both their names without an express trust. Equity presumes that the donee holds the property on trust for the donor, since the donor did not intend to do so, as per Lord Upjohn in the case of Van der Waals and IRC. When the property is transferred with no clear evidence of what the transferor intended, where the facts fail to yield a solution, the law will apply the legal fallback rule, which called the presumption of resulting trust. Presumes that the transferee hold the property on trust for the transferor. In other words, presumption of resulting trust applies only when either the donee or transferee is unable to provide any evidence of the contrary intention, that the gift was intended to him, or the relationship between donor and donee is not in a special relationship. In short, a presumed resulting trust arises in the transferor's favor when the transferee acquires a legal estate but has not provided that consideration for its acquisition, unless a contrary intention is proved. Apart from that, the contributor of the purchase price of the property prima facie acquires a beneficial interest in the proportion that the contributions bears to the total purchase price, as held in the case of Dyer and Dyer, when someone pays the purchase money for a property, but the title of the property is vested under the others. The law presumes that the property is held on resulting trust for the person purchased the property. This presumption can be rebutted if there is evidence showing that the purchaser intended to make a gift or there is a special relationship between the donor and donee. Also, in the case of redemption, it was held that when a person makes financial contributions, even indirectly, towards the purchase price of a property, they may acquire a beneficial interest in that property under presumed resulting trust. Also, only monetary contributions or non-cash contributions with monetary value are relevant, and such contributions must relate to the acquisitions of the property. Post-acquisition contributions are irrelevant. In short, presumption of resulting trust may be rebutted by providing evidence that the intention of the donor, in fact, is to make an outright gift to the donee, or there is a special relationship between the donor and donee. In cases of certain special relationships, the rebuttal presumption of advancement may be relied on to displace the presumptions of resulting trust. Similar to presumed resulting trust, presumption of advancement may also be rebutted by means of evidence of the donor's intention. This is a rebuttal presumption that operates in trust, contract, and family law. The presumption is that only in cases of certain recognized special relationships between donor and donee, property transferred by donor to donee without consideration is a gift from the donor to donee. The recognized special relationships giving rise to presumption of advancement includes the transfer from a father to child, from husband to wife, from man to mistress, as well as donor standing in local patrice to child. However, the presumption of advancement had been criticized that it is an outdated and discriminatory doctrine that perpetuates gender inequality and marital status-based distinction, which is conflicting the Human Rights Act 1998 and the European Convention on Human Rights. In fact, the presumption of advancement had been discriminated on grounds of sex and marital status in which the presumption had been applied selectively, such as transfer from father to child, husband to wife, and man to fiancé, but not to transfer from mother to child, wife to husband. This differential application is arbitrary and reflects gender stereotypes about familial roles. Such discrimination contravenes Article 5 of Protocol 7 of the European Convention of Human Rights, which guarantees equality of rights between spouses, and Article 1 of Protocol 12 ECHR, which prohibits discriminations. Hence, it had been argued that the continued judicial application of presumptions of advancement may undermine property rights and equality. As discussed above, presumption of advancement rests on outdated social assumptions and no longer reflect contemporary family and societal structures. Lord Diplock, in the case of Patai and Patai, condemned the continued use of presumptions grounded in the outdated assumptions of an earlier generation, calling their applications to modern marriage an abuse. In short, equalization or abolition of the doctrine is needed to bring the law into line with principles of equality and human dignity. Apart from that, in English law, in cases involving the matrimonial or family home, the presumptions of resulting trust does not apply. Instead, the donor's equitable interest is to be decided either by the inferred common intention or, in the absence of such intention, by the presumption that the equitable titles follows legal title as mentioned in the case of Stack and Dowden and Jones and Kernan. In short, to decide whether there is a presumed resulting trust, the starting point is to determine whether there is any evidence available relating to the intention of the parties. On the other words, the presumptions apply only in the absence of definitive evidence in the first place concerning the transferor's real intention. And yet, the courts may rebut the presumptions based on relatively slight evidence. The second resulting trust, laid out by Judge McGarry, is the automatic resulting trust, in which the creation of trust fails at all, or some part of the settlor's beneficial interest remain undisposed of. Here, the trustee automatically holds the property on resulting trust for the trustee to the extent that beneficial interest has not been carried to him or others. Also, the automatic resulting trust here does not depend on any intentions or presumptions, but is the automatic consequence of settlor's failure to dispose of what is vested in him. As we can see, there is difference between the two ways of classification, that relating to whether all resulting trusts arise as a result of intention of the parties or not. Judge McGarry's views is that intention is irrelevant for automatic resulting trust. But Lord Brown Wilkinson's view is that all resulting trusts are based on common intention of the parties. As a matter of fact, in justifying the imposition of a resulting trust on the ground of intention, there are two main competing theories, in which the Swadling Brown Wilkinson school views that resulting trust as giving effect to a positive presumed intention by the transferor to retain the beneficial ownership. In contrast, the Berks-Chambers school argues that resulting trust arise where there was no intention to benefit the transferee, which is a negative intention. However, it had been criticized that in practice, many resulting trusts arise when there is no actual intention at all, neither positive nor negative. For example, resulting trusts may arise simply based on the contribution to the purchase price of property where no intention was required. In the case of Vanderwell and IRC, a resulting trust was imposed though the transferor did not intend to retain any interest. Hence, it had been argued that resulting trusts arise by operation of law because the law upholds a vacuum in beneficial ownership, not because of any intention, in the absence of evidence to the contrary. In short, what is given effect is equity's imputation of a legal result in which it had been argued that neither a lack of intent to benefit nor a positive intent to create a trust is related with the presumption of the resulting trust, which is still remain controversial nowadays. Apart from that, the role of unjust enrichment in explaining resulting trust too remain highly controversial. Professor Peter Berks argued that the resulting trust operates to reverse unjust enrichment, and this had been developed in detail by Professor Chambers. All resulting trusts arise by operation of law is to effect restitution of unjust enrichment, in which should be seen as proprietary responses to unjust enrichment. Specifically, presumed resulting trust arise as the transferor is presumed not to have intended to benefit the transferee as a gift is not intended. Hence, the function of presumed resulting trust is to carry the enrichment back to the person who experienced the corresponding deprivation. The relevant theory suggests that all resulting trusts come into being because the provider of property did not intend to benefit the recipients. Professor Chambers contended that this provides a coherent and unified rationale for the diverse situation in which resulting trusts occur, aligning trust law with modern restitutionary principles. However, it has been criticized that treating resulting trusts as a response to unjust enrichment being doctrinally incorrect and a misreading of legal history. The rationale was rejected by Lord Brown Wilkinson in the case of Westouche and Islington London Borough Council. The House of Lords, in a case, confirmed that a resulting trust requires an intention to create a trust, which was contrary to the Berks and Chambers model. It was held that resulting trust, in fact, depends on the claimant's intention, actual or presumed, to retain a beneficial interest. Moreover, treating resulting trust as driven by unjust enrichment risks conflicting personal and proprietary remedies and undermining the essential distinction between restitution and trust. In English law, unjust enrichment typically gives rise to personal claims, not proprietary ones. Without a clear intention to create or retain a trust, imposing a resulting trust on unjust enrichment arounds alone risks creating unexpected proprietary effects that conflict with established property law principles. Therefore, while unjust enrichment may help explain why the defendant ought not to retain a benefit, it does not on its own justify the proprietary remedy of a resulting trust under orthodox in English law. In a nutshell, resulting trust is a trust implied by a law in situations where beneficial ownership of property is not fully disposed of or where the transferor did not intend to confer a beneficial interest on the transferee. The roles of intention, presumption, and unjust enrichment in relation to resulting trust remain complex and heavily debated. Overall, while each concept contributes to the understanding of resulting trust, the lack of coherence between them continues to provoke scholarly and judicial debate, leaving the law in this area unsettled and ripe for future clarification. Hence, to ensure clarity and fairness, the law of resulting trust should evolve through careful judicial development and reformation. Thank you.